Oh, he's over here.
Hear. All persons having anything to do before the Honorable, the Justices of the Appeals Court, down sitting at Boston, within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Meade. To my right is Justice Blake, and to my left is Justice Desmond. We'll be the panel for all of your cases today. If you haven't been here, or if you have been here, each side gets 15 minutes. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. With that, I'll call our first case, Commonwealth versus Matthews, 22P 1099, Mr. Dreschler.
Morning, Your Honors. May it please the Court, Justin Dreschler for LAMAAR Matthews. So, Your Honors, I'd like to start today with just the framing of this issue in this case, because it is something of a strange posture. In these sufficiency cases, we are oftentimes in this posture of, well, did they barely get over the hump? Is there what is sufficiency, what isn't sufficiency? Can any rational finder of fact have decided that this is enough for a conviction? And we are still under that same standard here, except that we have substantially more guidance from the courts than we would usually have because of this fingerprint situation. And so I think the framing up front is really important because this is an exclusion analysis, it's not an inclusion analysis. And that makes all the difference in this case. When the only evidence linking a defendant to a crime is a fingerprint, then the Commonwealth must couple that evidence with other evidence that reasonably excludes the hypothesis that the fingerprint was impressed at a time other than the crime. As I've said in my brief, and as the Commonwealth has acknowledged, it's very clear that the Commonwealth did that in the context of, could this fingerprint have been found on this phone or placed on this phone before the crime? We can all agree that they reasonably excluded that hypothesis. There's no question about that. It would be unreasonable to argue otherwise. However, they have not excluded the hypothesis that it was placed after the crime, but not only have they not excluded it, they haven't even really tried.
I understand the point you're making, but at the same time, the Commonwealth doesn't have a burden to exclude hypotheses of innocence, let alone ones that are not reasonable.
Well, Your Honor, I guess to that I would respond that I'm not even arguing that the explanations that could possibly be the reasonable hypotheses in this case don't require actual innocence. And well, Morris didn't require actual innocence.
The Sun says that one of the intruders handled the phone at the time of the crime.
Sure.
Why isn't that more reasonable to conclude that it was the defendant's fingerprints, 5 of them, on the phone, than that he found it in some bushes in the middle of some desolate area 20 feet off the road when it's like 15 degrees out?
Well, there are a few reasons for that, Your Honor, starting with the last first. I am not arguing. I understand that the trial counsel argued potentially that this individual could have happened upon this phone, that Mr. Matthews could have happened upon the phone while walking through the woods in the middle of the night, which is an unreasonable.
Yeah. What do you think? He was a joint venture in the car? You think he could have been just another traveler in the car with his buddies and somehow touched the phone?
I think there are many such scenarios, and I think that's exactly what Morris teaches us. And what's critical here, in this particular case, what makes it even stronger than Morris for the defendant, is that the intruder didn't match Mr. Matthews' description. And I really can't stress this enough.
But that doesn't view the evidence in the light most favorable to the Commonwealth.
Well, Your Honor, I guess I would argue that that's not true because there wasn't any counter evidence.
But the jury doesn't have to credit everything that it's testified to, right?
They don't have to credit everything that it's testified to.
It is understandable that someone in the middle, in the darkness of night, may not have had an accurate description of one's height.
Well, I would say that it wasn't in the darkness of night. Michael Vanette made it very clear that he got a good look at the intruder. Not only did he get a good look at him, he was certain that he was shorter. Not only was he certain that he was shorter, the first intruder, and this is
we can insert whatever qualifiers you like. The jury's not required to believe everything that a witness testifies to.
They aren't, but the fact finder is required, and this court is required to look at the evidence as a whole. Judge Cannoni did not make specific factual findings regarding whether she credited or discredited Mr. Vanette's testimony. Yes, all reasonable inferences.
He's not required to make findings.
Michael Vanette did testify very clearly that the second intruder was shorter than the first intruder
He may
and
have.
shorter than him.
He may have. But, I mean, first of all, we know the strength of eyewitness testimony is not always what we used to believe it was. And this is in the middle of an armed robbery in his house in the middle of the night. So leaving aside that he may have gotten the height wrong, how else, I mean, realistically, how else do we put the phone off some desolate road in Stoughton at some odd hour in the morning in the woods shortly after he was robbed?
Well, I don't think you have to think in terms of like, when you use the term realistically, Your Honor, and I think that realistically is probably perhaps a step too far. There are a number of different scenarios here that are not wholly innocent, and I want to stress this.
Let me ask you this question before you get to that. Were all of those possibilities, were they all argued to the jury?
No, they were not all argued to the jury, but in this situation, we're dealing with sufficiency of the evidence.
Or argued to the judge?
No, but with sufficiency of the evidence, it's de novo review. It's a due process violation, regardless of whether it was preserved or not, because sufficiency is always preserved under that context, because it would be substantial risk of a miscarriage of justice if someone was convicted of a crime for which they weren't guilty. But in any event, Your Honor, in this situation, we have a number of context clues that suggest not only that there was a getaway driver, but that there was some level of pre-planning, that there was some level of post-crime communication. We have Mr. Daniels' phone just littered with texts and phone calls before and after the crime, in close connection with the crime. Where are you at? I'm right here, pull up on me. A 2-minute phone call after the crime from this 347 number. Text from the Zanny individual, text from Junior. We have all of these things suggesting that Mr. Daniel was trying to connect with someone, which suggests that more people were involved in this crime in some way. Why could Mr. Matthews not have been Zanny? Why could Mr. Matthews not have been Junior? Why could he not have been that 347 number? Why could he not have been a passenger in this car? Why could he not have committed some sort of crime in terms of pre-planning? This is exactly what Morris is. There's just no logical distinction. There really isn't. It's just a before or after argument. In Morris, the defendant was so closely connected to these White brothers, to the actual intruders. You got his fingerprint on a clown mask of all things, something completely unreasonable. So let's think about what the possibilities are in Morris, right? So in Morris, we have a few possibilities. One, he's a principal intruder. Definitely a possibility, no doubt. The court even acknowledged that in its actual holding. He may have been one of the intruders. Two, he was involved with these guys closely. He was involved with the White brothers. He was involved in planning it. That was his clown mask, etc. Three, he's totally innocent. They just happened to hang out of this house. He happened to handle this clown mask that was used in a robbery later. Number three is ridiculous. Number three is obviously not true. But what the court said in Morris is we cannot distinguish between 1 and 2. And that's what we're saying here. There just is not enough evidence to distinguish between 1 and 2. The Commonwealth had plenty of opportunities to distinguish between them. They could have done a non-suggestive ID of Mr. Matthews with Mr. Vinette. It would have been months later. Some trial counsel would have aptly attacked it, surely, but they had an opportunity to strengthen their case. Instead, what they did is they relied on this fingerprint. And when you look at the whole context, and just to answer your question, Justice Meade, to address what is a fair criticism, which is to say, well, we don't have to just assume that everything that Mr. Vinette saw is true. But when you consider all of the other context of this case, it's not just about LAMAAR Matthews is not nearly the same height as the intruder. It's not just about, well, Michael Vinette was able to identify Valerie Daniel, the other intruder, immediately in a show-up identification. He was able to say, that's the guy. It's not that Michael Vinette said, I got a really good look at him. I'm 5'10". I know what a 5'10" guy looks like. He's right in front of me, and he's way shorter. It's not just that. It's that, plus we have all of these text messages. Plus, we have the second intruder just getting away despite a police dragnet, which essentially had to have happened with a getaway car. We have all of these things that suggest that there are many ways that those fingerprints could have gotten on the phone. And Mr. Matthews doesn't have to prove to you that he's innocent. He doesn't. The Commonwealth's burden here is to reasonably exclude all of those hypotheses.
Would your argument be different if the phone was found, let's say, within 15 minutes of the crime?
I think that no, I don't think within 15 minutes.
About 10
Within 15
minutes?
seconds, maybe.
Well,
I think there is a
I'm gonna
line.
work the clock with you, 10 minutes.
Okay. Let's see. So the phone is half a mile away. No, I think the argument is
5 minutes,
nope.
1 minute.
Yes. I think there's a line, Your Honor. I think there's no question that there's a line. I mean, courts are asked to draw lines all the time. You're being asked to draw a line in this case. If it was 3 months later, I would think the Commonwealth wouldn't even vote the
What if instead of 1
case.
mile from the house, it was a half a mile?
I'm sorry, half a mile from the house. Far enough that it could have been traversed very easily by car or by foot within a handful of minutes, I would say, is really the litmus test here.
Exhibit 16 and Exhibit 17 don't suggest to me that it was easily accessible by a pedestrian.
Completely agree. I think that's why, one of the reasons why I acknowledged right in my brief, and the testimony from the recovering officer, I think was quite clear that it was not a pedestrian just walking into the woods. I mean, you're talking about a phone that's
Is it your
buried.
hypothesis? I'm trying to understand what you think happened. You're not challenging the evidence as to the fact that the print likely was not impressed before the crime, right?
Nope.
So somebody throws it out into the woods. It lands where it lands with the light on, as folks said it would be found. And then somebody walking by picked it up and impressed your guys' prints?
No. The theory here is that Mr. Matthews could have either been the getaway driver, and I want to just reframe this for a second. I am not telling the court what happened.
No,
I am telling the court
but I'm
that
trying to understand what you think happened.
I am saying that it is a completely reasonable hypothesis that Mr. Matthews could have been in the getaway car, could
Okay.
have been the getaway driver, either wittingly or unwittingly, because it doesn't matter. He
Touch
can't
the phone.
touch the phone. He can't be
Then it
convicted.
goes
of
out
crime.
the window of the
Then it
car.
goes out the window. It's not really even a little bit hard to imagine a scenario where picks him up. Oh, I didn't get whatever they were looking for. It's a bizarre breaking and entering since we
Were
have
they
no idea what
instructed
they're
on
looking
joint
for.
venture?
Excuse me?
Was the jury, I'm sorry, it's jury waived, right? So
It's jury waived and the
the
Commonwealth
judge
didn't
could
argue.
have considered joint venture.
The judge could consider joint venture. The Commonwealth didn't argue it. I mean, not that it would be waived, but the Commonwealth didn't even consider that as a possibility, joint venture. I think if the Commonwealth had considered joint venture, I don't see how they could get there anyway, because there's just no evidence of joint venture, which probably sounds like I'm having my cake and eating it too.
There's two of them.
Excuse me?
There's two of them working together breaking into this house.
I'm sorry. There's joint venture clearly with regard to the two principals.
And there's a
But what I
getaway
mean is,
driver.
there's no joint venture with regard to a getaway driver, and that there's not sufficient evidence to get the Commonwealth over the bar for a getaway driver joint venture, because it would just be too much speculation. And again, you might say, well, Mr. Dreschler, well, you're having your cake and eating it too. You're saying this is a reasonable hypothesis.
That's what I was thinking.
Yeah, but I'm not, because of the burdens of proof. The Commonwealth has a burden to prove beyond a reasonable doubt under a joint venture theory, and the burden here isn't even on me or Mr. Matthews. The burden is on the Commonwealth to exclude this as
Told
a
us it's a
possibility.
reasonable inference that Mr. Matthews is the getaway driver.
Is it a reasonable inference that he was the getaway driver?
You told me it was.
Sure, it is. But you still have to prove the requisite intent, and there's no evidence. You have to supplement that with the requisite intent.
Well,
which-
we can supplement it with his fingerprints, and we can supplement it with the fact that one of the intruders took the phone from him.
doesn't get you to the intent, particularly with the armed, with
What the intent to commit, which of the several crimes he was convicted of?
So at least 7 of them require the element that have an element that the individuals entering the home were armed. And Commonwealth versus Booth or Buth, I don't know how you pronounce it, B-U-T-H.
Well, the son testified that he thought he had a knife and said he was going to cut him.
No, I'm not saying that the intruders weren't armed. The intruders were armed, but any co-venturer, any joint venture must share that requisite intent and must know that they were armed. And Booth teaches us that you can't just assume that all joint venturers knew that the individuals were armed in some way. You have to find some other evidence that allows you to hang your hat on that. For example, if they were...
You don't make a separate claim that he could be not guilty of some of these offenses based on what you just said, right?
Some as opposed to all?
Yes.
I think that it's possible to split the baby in this case, but I
No,
don't
I
think
said,
you should.
did you argue that in your brief?
Do I argue it in my brief? I argue in my brief that he is not guilty of all of these offenses under the principal liability theory, under the principal intruder theory. And then I specifically delineate, by way of example, the armed sections of the, the statutes that require that the individual intruders be armed, because those require some sort of requisite intent. The other two are breaking in the nighttime with the intent to commit a felony and assault and battery, which I would argue, likewise, because there is no evidence of pre-planning, that they can't convict under there. And again, it seems strange, but it's not. It's not, because the Commonwealth...
Getaway driver connotate knowledge of some wrongdoing?
I'm sorry,
The
Your Honor.
getaway driver, he was the getaway driver. Doesn't that connotate some knowledge of wrongdoing? How can you be a getaway driver if you didn't know there was something going on?
Well, what I would say, Your Honor, is that there are lots of different types of getaway drivers. Booth, Canonas teach us that, and that different ones have different levels of knowledge. Second, it's not the only possibility. There are a number of different possibilities that we've articulated here. He didn't have to be the getaway driver. He could have been someone in the car with the getaway driver. Zanny's texting, and then a 347 number is calling. It's really not hard to imagine these scenarios, Your Honor. And with that...
Yeah, thank you.
Thank you.
Mr. Schillinger. Schillinger. Close.
Schillinger.
Thank you.
Thank you. Good morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. It's undisputed here that the Commonwealth presented sufficient evidence to reasonably exclude the hypothesis the defendant touched the phone prior to the commission of the crime. So I want to focus on the other two time periods, during the commission of the crimes and then afterward. During the commission of the crimes, and to pick up on Justice Meade's point, we have a very significant piece of evidence, which is we have direct evidence. The victim saw the assailant, and it's the assailant that the Commonwealth contends was the defendant, the shorter assailant in the green hoodie, touched the iPhone, took it from the victim's hand, manipulated it to turn off the flashlight, and put it into his pocket. That is a significant piece of evidence that in many of these other fingerprint cases we don't have. And I would point the Court to Commonwealth versus Keaton. This is cited in my brief, and it's at 36 Mass App Court 81 at page 85. And the Court notes there, similarly, the victim saw her attacker touch a water goblet, and the defendant's fingerprint was later found on that goblet. The Court noted...
Any other fingerprints on the phone?
I'm sorry, Your Honor.
Were there any other fingerprints on the phone other than the defendant's?
There was one other fingerprint that the defendant was excluded as the source, but the fingerprint analysis or expert was unable to identify any particular person because it was a partial print.
So why couldn't that guy have been the assailant? Why couldn't that print have been the assailant?
It's a hypothetical possibility, absolutely. But the Commonwealth doesn't have to exclude any possibility or any hypothesis. It has to reasonably exclude the hypothesis that the defendant touched it at some time other than during the commission of the crimes.
So how do you reasonably exclude that their partial print wasn't the assailant?
I'm sorry?
How do you reasonably exclude that the partial print wasn't the assailant?
Again, pointing to the evidence here that the defendant's fingerprints are on it, and then later on, where the phone is found, the circumstances in which it's found, excludes the possibility that it was touched at some later point in time as well. So, and as to the possibility that there was some other third individual involved, and that was the defendant, and honestly, I think that's where we're at here. That's now the defendant's core theory. I was a getaway driver, I was some other third individual involved. I think the Commonwealth did present evidence that reasonably excluded that hypothesis, and the key evidence here is the police response and their presence and where they were, how quickly they were there. And I would point the Court to it, and to put a finer point on it, the police arrived in the immediate aftermath of the crimes here. There was evidence that Jameer's younger brother had called the police while the crimes were still ongoing. The police arrived within a minute or two of the dispatch at 2:50 a.m. There's testimony to that effect. And I think it was Officer Gallagher who testified. The entire shift of officers responded to this call.
And none of them saw a car on the road, but yet we know a car was on the road, right?
We don't. We don't, and I think that
how'd the phone get in the bushes?
I'm sorry?
How'd the phone get in the bushes on this desolate road in Stoughton?
I think that the Commonwealth excluded the possibility that there was a vehicle on the road between the time of the crimes and when the phone was discovered, and it's, instead, the explanation would be the defendant traversed that area, and the officers testified that you could get from the Vinette's home on Pratt's Court to where the phone was found by cutting through backyards, cutting through brush. And so it was entirely possible, and the evidence showed, the defendant could have fled the home, cut his way through yards or backyards. on foot, exactly, which would be consistent with traversing about a mile within an hour's time, and discarded the phone, whether, was in that particular area of the woods and threw it down, or whether it was somewhere nearby and chucked it, doesn't matter. But the evidence was consistent with that theory of the defendant fleeing on foot, getting to that location on West Road, discarding the phone. Now, after he does that, is it possible that he then rendezvous with some other person, gets in a car, takes off, and goes to his home, which is 20 miles away, or maybe goes to some other location? Absolutely, not contending otherwise. But I think the evidence did reasonably exclude the hypothesis that he was simply a getaway driver in a car on those roads between the time that the crimes occurred and when the phone was found. And I think that's the key distinction there, Your Honor, is that we're focused on that time frame and that location. Entirely possible that after the phone was found, he got away. In fact, the police didn't find him until months later, so he must have gotten away. He may have gone somewhere, may have rendezvoused with somebody, may have reached out to Mr. Daniel to find out, where are you, what's going on, where are we going to meet up? But the key part is, during that time period, that 1 hour time period between the victim's home and where the phone was found, the officers testified, and viewing the evidence in the light most favorable to the Commonwealth, nobody on foot, no pedestrians, no vehicles. And it's not just in one place, they were everywhere. They were north of the home, they were south of the home, they were on West Street where the phone was found, they were on Central Street above where Mr. Daniel was found. And Mr. Daniel was found alone. He wasn't found with another individual. So I would contend, Your Honors, that all of that evidence taken together and viewed in the light most favorable to the Commonwealth was sufficient to exclude, reasonably exclude, to Justice Meade's point, don't have to exclude any hypothetical possibility or theory of innocence, just have to reasonably exclude the hypothesis that the defendant touched the phone at some other point in time and not during the commission of the crimes. And just to circle back again, the evidence, the direct evidence, that one of the assailants touched that phone, I think is very significant here and distinguishes this case from many of the others that are cited by both parties in their briefs. As I mentioned in Keaton, the court noted that evidence that there was a fingerprint on the goblet that the victim had seen the assailant touch strongly linked the defendant to the crime. Now, the Commonwealth is not contending, as the defendant suggests in his reply brief, that evidence by itself wins the day. That's not our position or our theory. I do think that evidence would support an inference, obviously, that the defendant touched the phone during the commission of the crimes, and it's a significant piece of evidence, a plus factor, if you will. The last point that I would mention, Your Honors, and again, I think Justice Meade made this point, all of these arguments relating to identification-related evidence, the disparity between the father's testimony as to the height of the second assailant and what Mr. Matthews' height and build was reported as on his booking sheet went to the weight of the evidence. It was for the judge sitting as the fact finder to decide what, if any, weight to give that evidence and to resolve any discrepancy there, but it didn't render the evidence legally insufficient. Unless the panel has any other questions, the Commonwealth will rest on its brief.
Thank you. Thank you, Bull.
Thank you, Your Honors.
Our next case is 23P423, Commonwealth versus GROTHE. Mr. Nadeau.
Thank you, Your Honor. Good morning. May it please the Court. Stephen Nadeau on behalf of the Commonwealth. We are here on an appeal from a judgment of the Fall River District Court where the trial judge on the day of trial, it was the third day of trial, dismissed a case for failure to prosecute with prejudice. We are not challenging the dismissal in and of itself. However, our position today is that the dismissal with prejudice was an overstepping of the judge's authority, given that there was no showing either of egregious prosecutorial misconduct in the case or a serious threat to, or serious prejudice to the defendant's ability to obtain a fair trial. I would suggest this falls in kind of those line of cases where the frustration that the Commonwealth was not ready, particularly after the case had been marked no further continuances. I imagine the prosecutor was quite frustrated under the circumstances handling the
How
case,
come there
having a
hadn't-
child witness.
I'm sorry. How come there hadn't already been a competency hearing before, was it the third trial date?
I'm not sure why that would not have been scheduled. I know that there was a motion filed, styled as a motion in limine to sort of address that. I don't know whether that was, obviously, as the record sort of indicates, there had been some difficulty getting in contact or in meeting with the child. You know, the father showing up on, I think, the second trial date. I didn't know he was supposed to be here, that kind of thing.
But wasn't there a representation made that Commonwealth was ready for trial and the prosecutor had not even talked to the child? Is that accurate?
I believe that's probably accurate. And I think at the time the prosecutor made that representation, the understanding was, you know, we have this witness contact. We believe we can get them there. That was a good faith representation at the time. I think.
I don't know. You wait till the morning of trial to put a child witness on the stand?
A child who's 5.
Exactly.
Well, 6 at the time.
Oh.
That doesn't improve things dramatically, I acknowledge.
I don't know, you know.
So do you think that that's pretty egregious? This is the second or third trial date, right? It seems to me that you make an argument that, you know, we should be able to, because of the nature of this case, the Commonwealth, you know, has a strong reason why it may want to prosecute this case. And so you say that in one breath, but on the other breath, you haven't interviewed the kid, he hasn't been with a victim witness advocate, it's the third or fourth day of trial. How do you kind of balance those two things? If it's so important to you, how come nobody's reached out and had any conversation or interviewed the child before the third trial date?
Well, I'll say the record does not disclose what efforts were or were not made or what lapses there may or may not have been.
Is it fair to say the Commonwealth had no contact with the child before the third trial date?
At least certainly I've not met with him prior to that, although there had been the forensic interview. I'm not sure what outreach the advocates had made. It appears that it was sort of the traditional, I know when there's a child victim involved, extra efforts are made, but the reality being what it is, you're kind of dealing with a parent as an intermediary. The realities of a busy district court, again, very frustrating, but doesn't rise to the level of egregious, intentional, and deliberate misconduct. And I think it's the Borders case. We understand the frustration. We would have that same frustration on the morning of trial.
So prejudice is also an issue, right?
I don't. There are certain sources of prejudice cited by the defendant.
That's my question. Does it have to be prejudicial with respect to him getting a fair trial, or he says prejudice, mom hasn't been able to see the kid for 153 days or whatever it was?
So as I read the cases, prejudice to a fair trial, and none of the sources there, certainly not frivolous from the defendant's perspective, but don't implicate the trial right specifically. There may be other situations where the prejudice is so egregious that a collateral matter might implicate with or without prejudice. But also as to that point, there's been no showing, and I can't think of any reason why the with or without prejudice would make much of a difference in terms of, the DCF proceedings, probate court proceedings.
What about the parallel proceedings that were going on with respect to mother and father and the custody issue of the child?
Well, the case would still be dismissed. The case would have been terminated at that point, and I think it ceases to be, an active case, so, the father would have no leverage in the probate court. And the fact of the matter is, for all the frustrations with a young child victim, those are the same reasons why, we do not want to let the order with prejudice, so we don't know what this child may be capable of, what maturity might bring with him in a few years within the statute of limitations period, and that's the balance that Article 30, the statutes of limitations themselves strike. And, at some point, these proceedings must come to a final end. But at this point, the dismissal with prejudice as opposed to without was too draconian a sanction, absent serious prejudice to the trial right or egregious and not just a lapse, perhaps, on behalf of the Commonwealth. There'd be no showing on either of those prongs. We would ask the court to overturn so much as the order was with prejudice. If there are no other questions, I would simply rely on the brief.
Thank you.
Thanks.
Mr. Markey.
Thank you, Your Honors. If it pleases the court, Attorney Christopher Markey from New Bedford on behalf of Ms. GROTHE. We got to put this in perspective. On May 7th, 2021, the defendant was arraigned, and the Commonwealth believed that this woman was of such a danger to her child and to the community in such a significant way they were willing to take away her liberty. Yet, by April 11th, 2022, they had never met
Are
with
you
the
arguing
victim.
deliberate egregious misconduct, or are you arguing?
I think there's two things. One is that, and one is the prejudice. And I think when you look at this case, and again, could I have done a better job of making a record of all this and the judge make a better record of all this? We probably could have, without a doubt. But when you look at this and what was presented at that date, we got to look at everything. And when you go back to May 7th, they file for the dangerousness hearing. The court doesn't find her to be a danger, but prevents her from seeing her son, who she has custody of.
Well,
And now
there
put-
was physical evidence that supported the DA's concern, right?
There was what?
Physical evidence.
Yes, there was a police report.
No, there were bruises and there were cigarette burns.
Well, there were three different versions of the events from the child. The first,
I'm interested in what the medical person said.
you could decipher out of this record facts that you wanted to find that the defendant committed a crime. You could find bits and pieces of it, but when you looked at it, realistically, the first time the child divulges anything is he's wrestling with his cousins. And I believe the case would have shown that had it gone to trial.
You got cigarette burns?
No. If carpet burns, and they didn't even have an expert here to testify to that effect. It's clear. There's no round hole or anything to suggest a deep cigarette burn.
I'm sorry,
It's a scuff.
what was the adverb you used for the burn?
A carpet burn.
Carpet burn.
Carpet burn, wrestling with
Why
her.
did the defendant say she fell asleep and dropped a cigarette on him?
She never said that.
Where did that come from?
Not from her. She didn't make a statement.
That's it. That's in the it's in the brief.
There's no statement made by my client. So now we go to July 12th, 2021, where we fill out a pretrial conference report pursuant to Rule 11. And when we do that, there needs to be meaning behind that. There's notice, there's all of that. We put in there that there's competency issues.
Do you think the government's actions were deliberate?
Yes.
Go ahead.
Why?
Why? I don't know why, but it's beyond comprehension that you have a child who, if you believe everything the government says, has burn marks and bruises from her mother, and in addition to that, she takes a piece of hair and puts it into his penis.
Do you think gross negligence is the same as deliberate?
I would say that when you look at this, this is deliberate. So I couldn't tell you. They're clearly not, because they're two different descriptions of things. But between May 7th and April 11th, they meet 0 times with the person. 0. So now you go forward. We had 2 trial dates. They were one from the fall was continued, I think, because of it might have been both because of COVID or something like that. So now we're at May 21st. And again, having understanding, as Mr. Nadeau has mentioned, it's a busy district court. You answer ready for trial. Okay, you're ready for trial. You're going to the next courtroom. We go to the next courtroom on March 21st.
No, I think we all agree with that. I mean, the fact that there hadn't been a competency hearing on
They hadn't even met with the
I haven't
person.
finished. There hadn't been a competency hearing on someone who's under 7 or met with them certainly is odd. But it really goes to the heart of what I think Justice Desmond is trying to inquire of you, is where do we draw the line between malfeasance, negligence, gross negligence, and egregious deliberate misconduct.
Well, what else? I don't think that you can call this gross. You meet with the kid early
Mr. Markey,
on.
you have a lot of experience in district court, right?
Yeah.
Yeah, so you know how things work in district court. And everything isn't always rosy and peachy and creamy. And weird stuff happens all the time. I think our most interesting cases we hear in the appeals court have come from the district court, without a doubt. The superior court does stuff, lengthy stuff. But at the same time, that doesn't mean it was intentional. I mean, what was the government going to gain by the inactions that they had visited on this defendant?
Bluntly,
Yeah.
cover your butt. They were not going to have it. They need coverage for this, because if this ever blows up, they're going to get blamed for it. Okay? That's it. But they did nothing. It's incomprehensible. It's incomprehensible of how it can go through 3 trial dates, and 2 of the times they answer ready for trial, and 2 of the times the person's not even in the courtroom, and 2 of the times they've never met with the victim.
So could I ask you a different question then? So the statute of limitations for these crimes is 6 years. So the legislature, in considering your prejudice argument, has determined that a case like this potentially could be open for 6 years. And I know at the time that it was dismissed, there had been a year that had been passed. How do we factor that in to your prejudice analysis?
What I would say is the prejudice is clearly, and again, the cases, I think, of Burston and Paula and LeBreton, those cases all talk about potential prejudice as well. And I would suggest that this mother who hasn't seen her child for a year is a prejudice.
Yeah,
But
there's
doesn't-
not prejudice
inconvenience.
to a trial. It's prejudice in terms of whether or not she can get a fair
But I
trial.
think the analysis of
Not
the-
whether or not she's, not allowed to see her child. I mean, I get that, but that's not what the cases speak to.
But the cases talk about the inconvenience and the costs of doing things to make a determination as to a continuance and the degree of a dismissal.
Those were not the reasons the judge gave, though.
The judge, I would suggest that the court gave both the prejudice that I expressed, that the fact that she hadn't seen her child,
All right,
and
so,
also
well,
that the
putting,
fact
putting
that...
aside that, a lengthy familiar exclusion of mother from child is prejudicial, it does not go to her ability to defend against the charges. The judge was concerned that witnesses' memories would fade over time. Again, something the legislature has considered when they enacted a 6-year statute of limitations, or included this in the crimes with, but again, I mean, I don't see how witnesses' memories fading helps the Commonwealth.
It could be effective to mine in the witnesses that were being called, who were the people who were wrestling with the young boy, and how they determined how the other cousins who would have been witnesses who would have testified and could have testified as to exactly what they were doing and how they put him in a headlock and how they were throwing him around and how he was doing the same to them.
Were they on your witness list? Were they going to be called?
They were witnesses. We had 2 witnesses that we were prepared to have to testify.
I just want to revisit for a moment. You said that it was, the motivation may have been for the Commonwealth in terms of covering its butt. And I'm not sure I fully understand that.
Okay.
What do they have to gain from not interviewing the 5-year-old child before the trial, on the first day?
In my mind, their concern is they learned 6 months before that this child could never testify.
Okay, so what do they have to gain?
And they dismissed the case 6 months before.
Yeah.
And they lose leverage on trying to get a potential plea out of the woman or anything that they can, depending on who the judge is in the district court. I guess my problem is they think this is the most serious case on May 7th, 2021,
get
and they
that.
do nothing. I mean, it's not like Okay, well, we forgot to do that, or in all these cases, we forgot to bring a witness, or Officer Malley in Clegg wasn't available, he was out of state, or whoever it was, whatever the circumstances. But they never did.
Assume I agree with you on that. That's why I went to the question of prejudice. And I too understand from my prior life, separating a child from a parent. And the probate court judge could have done a lot of things with this dismissal, including supervised visitation. So I don't see that as the legal prejudice that our cases describe. And I'm trying to figure out if the legislature said that the Commonwealth had 6 years to bring this case, and it was dismissed after a year, they still had 5 years that they could bring it.
So this is what I would say is, and again, if you look at what I made representations of at the court, is this is what has happened since 2015. Every time there was a change in the probate orders, the father made an allegation against either her or her family.
So
And
none
that's
of
the-
that is unusual. It's unfortunate, but it's not unusual. It happens every day in the probate and family court. But what happens there, do you have a case that says that what happens in the probate and family court is proof of prejudice in a criminal case for these purposes?
What I would say is that this is where this would be, there's no finality in the end on a motion, on a dismissal without prejudice. It's not final.
For 6 years. After 6 years, there would be.
Yeah, a dismissal without prejudice is not finality. So a probate court could easily say, well, that's not final. That's not a final judgment. DCF, as we showed after, reversed their decision. The child is now with the mother and living with the mother, and she has legal custody of him, and the father has some visitation of him. So those things would never happen if it was dismissed with prejudice, without prejudice. Those things would be say, well, it's still out there, it's still hanging out there.
Show me a case that says that in the context of a criminal case, prejudice can be defined by what occurs in a related civil proceeding.
I don't think there's a case that says that. But what I would say is, again, going back to 2 young child witnesses on the defense side would testify that this one scrape on his knee was a rug burn, and that the bruising was from each other having to wrestle when the mother was at work and they were at the aunt, as the child was at the aunt's house. That is where that could happen. And in light of the conduct, you look at that prejudice, and the judge did the right thing with dismissing it with prejudice.
Could I ask you, in the record at page 14 is the pretrial conference report. You were counsel below, right?
I was.
So on motions, there's a motion in limine Ray Sane interview, but then there's something that says motion Ray competency of witness victim. Whose motion was that?
That was my motion. That's why that was my handwriting.
Motion
Those
for
three
competency hearing of the child victim.
Those 3 motions that I put in the page 14 under the pretrial conference report it's my handwriting.
And did you mark them up for the morning of trial, or did you mark them up for hearing before trial?
I marked them up to give I gave them notice, 1, and 2 is we were going to handle it the day of the trial because competency could change throughout.
So were these motions marked for each of the trial dates?
Yes, well, those motions were 5.
In other words, the Commonwealth was on notice of your motions for each of the trial
Yes.
dates? That's not clear on the docket, that's why I ask.
I just asked you to affirm the district court.
It's a tough go.
It is.
I see the negligence. I don't know that anybody would dispute that there was some negligence. I think the Commonwealth could concede there was some negligence. But was it deliberate? You're having a hard time, for me, as I sit here right now, seeing what they would have to gain by deliberately engaging in the conduct that we've seen in this case.
But isn't there a deliberate indifference to this? It's like, well, whatever. The Pretrial conference report really doesn't mean anything. Answering ready for trial twice really doesn't mean anything. I mean, if they weren't doing it deliberately, they don't meet with the person, yet at the same time they're answering ready for trial. That's not negligence. That's not gross negligence. That's a thought process going through an assistant DA's mind saying, I'm ready for trial.
I mean, to Judge Meade's point, it's district court. I don't know that it was the same prosecutor on the first day as it was who answered ready for trial on this particular day. I mean, you know, we've done this for a long time. I think the father's bringing the kid here. I'm going to put him on the stage. I'm ready.
I get it. I understand, but I do think that this case falls squarely different than many other cases because of the absolute indifference the Commonwealth has on the case. Thank you.
Thank you. Thank you both. The next case is 23P 353 Commonwealth versus Ostrander. Mr. Cohen.
Good morning, Your Honors. Attorney Cohen on behalf of Jason Ostrander. In this case, the trial judge erred and should have allowed defendants' motion for required finding a not guilty for witness intimidation. At issue at trial was a letter written by Mr. Ostrander to the victim while he was held pretrial. In the letter, there were no overt or implied threats. There were no gestures other than perhaps a written smiley face. The letter discussed problems with the relationship, finances, money. The letter also delved into Mr. Ostrander's case. Specifically, at issue was, as presented by the prosecutor, was this sentence. My lawyer said the courts are supposed to be open July 1st, so he's going to ask for a speedy trial, which then the DA has no case because no physical evidence, and you're not going to show, right?
Why don't we stop right there? Why isn't that an implied threat or an expressed threat?
Well, Your Honor, I'd like to draw an analogy.
I will too. You go first.
The Commonwealth relies on a case called Gardner. I suggest that the facts in Mr. Ostrander's case differ substantially from Gardner. In the Gardner case, it involved a situation where a victim suffered severe physical injuries over a period of years. The case references a barrage of phone calls and a trove of letters to the victim. The victim says, it was driving my head crazy. We suggest that in regards to the facts, Mr. Ostrander's case is much more analogous, very similar to a case, Hamilton. This case is unpublished, but I suggest still persuasive here. In the Hamilton case, there was one alleged incident of a physical altercation similar to Mr. Ostrander's case, and there was one incident of communication. In Hamilton, the defendant met with the victim and said several times, say the truth, it were an accident. So, again, in Mr. Ostrander's case—
There's something inherently altruistic in a request for someone to tell the truth, as opposed to threatening someone not to come to trial and testify.
I agree, but—
And the way he phrased it, it's my term for the analogy, the way he phrased it sounded a lot like a question a lawyer would ask on cross-examination, or an appellate judge would ask a lawyer standing at that podium, right?
Sure, it can be interpreted that way, but you know the other—
And can the jury interpret it that way?
Well, they did. The jury did interpret it that way, but I submit it shouldn't have gone to the jury. Again, the motion for required finding, the judge shouldn't have allowed it to go to the jury.
Well, if it's a reasonable and possible inference that what he said was an implied or expressed threat, then that goes to the jury, right?
If the judge finds that, yes.
I mean, you agree it's not what you say oftentimes, it's how you say it, right?
It's how you say it.
All right, so that's what we have here.
Thank you, Judge.
And now if you're looking at that language in terms of a victim of domestic violence, how she hears it is important, right?
Yes and no. As we know from the Rivera case, the jury is supposed to apply a reasonable person standard. It's not so much about necessarily just how that particular victim interprets something. It's a reasonable person, and it has to be in context.
It's a reasonable person under the circumstances that are presented here,
Yes.
which is an abusive
Yeah,
relationship.
right. It's in the overall context.
Blaming her for him being in jail.
And within the context of the letter. The letter itself, I submit, is not threatening. It talks about a variety of things. If there were to be a letter from a former boyfriend, girlfriend, it talks about things that you would expect. The relationship, money, the case. Of course, it's going to discuss the case. And certainly there's no overt threats. Just that one sentence, you're not going to show, right? But I suggest that particular sentence, that the jury looked at there, perhaps they would have put more, seen it more in a threatening way than they should have, because there was another area of the case in that the judge, there was an abuse of discretion. The judge did not allow defendant's motion for a new trial. In that same letter, based on ineffective assistance, defense counsel knew there was a problem with the letter and that there were about half a dozen statements referencing the fact that he was being held. Typically, this is something that defense counsel seeks to hide from the jury. A defendant typically would wear street clothes, et cetera. And of course, the concern is that the jury would put it towards character, towards propensity. And in that same letter, there were these various statements. I'm held for 120 days. I have some money for phone calls, but I want to exchange it for commissary. I get 2 calls per week. In that same letter, where all these various statements referencing that he's held pretrial, of course, that's the same letter where he says, you're not going to show. So,
but defense counsel has filed an affidavit that explained what his thinking was, his reasoning, his tactic, in that if he had it redacted, he feared that one could draw a worse conclusion than the fact that he was only there for 120 days. Now, that ultimately failed as to one charge. He was acquitted of strangulation. Why is that manifestly unreasonable?
I suggest that that affidavit makes more sense if you were to focus specifically on the 120 days. But again, there were about half a dozen statements in the letter that indicated that he was held. I think if all of those statements
were redacted,
He was
saying that they could believe that he was being held for longer or for something more serious.
The fact that, I'd submit the fact that telling the jury that he was held for 120 days is not a cure for the idea that the jury might speculate as to how long he was held. Whereas what could have and should have been done, we submit, is that defense counsel should have redacted all of those statements indicating that he'd been held.
Judge Mulqueen had already said, though, there was probative value to the fact that he was incarcerated.
Perhaps, but we suggest that it was more prejudicial than probative. Yes, certainly the letter should come in.
But you have to do more than that. You have to establish, like I said before, that his decision, his tactic, was manifestly unreasonable. Not just that it failed in part. He succeeded in part.
The particular error about not redacting all of those statements, those half a dozen statements indicating that he was in jail, it's the same letter that went in front of the jury. So it exacerbates the concern that the jury would have put the fact that he was held and considered that improperly, to character, to propensity evidence.
Well, then why didn't they convict him of strangulation? Because if he's such a bad person.
The evidence or the testimony of the victim as to that was equivocal. She said one thing to the police officer, she said something else on the stand.
Or that the judge instructed them not to consider it for that purpose, which she did, and she said they're presumed to have followed that.
She did provide an instruction. We'd submit that the better course would have been just to hide it from the jury altogether.
Well,
the fact that he was held.
hindsight is 20/20, and that's not the standard we apply.
Right. Well, I suggest, Your Honor, for example, if we look at the Reddy case, there was a comment in there that the evidence of the crime was not overwhelming and tied to the credibility of the victim. So here I suggest this one question as to you're not going to show within the context of the whole letter. It's not overwhelming. The victim's testimony.
If we conclude that it's a threat, okay, implied or expressed, and it's the defendant's writing, he put it in writing.
Well,
Why isn't that overwhelming
Your Honor,
evidence?
I'm not sure that I would agree that it's a threat. A threat typically
No, I said if we decide
involves
it's a
a
threat,
consequence.
and his goal was to convince her, intimidate her, harass her into not appearing for trial, and it's in his own handwriting. It's not someone overheard it. It's not someone recalling what may have happened. He wrote it down.
Your Honor, of course, when you have a couple and they're communicating, and one person may want another to do something else, and ask them to, for this favor, it doesn't necessarily follow that question is intimidation or harassment. There are various reasons that when people are in a relationship that, someone may not want to testify. Immediately following the incident, in fact, the victim didn't want to speak to the police.
But you're taking it out of context. He's just said there's no physical evidence, the DA doesn't have a case, and you're not going to show up to testify, right?
Your Honor, I know you put an emphasis on that, right?
Yeah.
But
and I did it intentionally.
There is no gesture. There is no intonation in a letter.
I don't know if you properly, not much of the letter is properly punctuated, but I'm not sure if it's set off with a comma or not. But it does say right.
It does.
Which suggests, like I said before,
very close to that is a smiley face.
Which does suggest
there's a smiley face very close to that.
Not on that. He does not give a smiley face after he threatens her not to testify.
Not that particular sentence.
No.
Very close to that
She knows
sentence.
the speaker, right? I mean, are we supposed to ignore that she knows the speaker?
They lived together for 5 years, so, yeah, a reasonable person in a relationship, I would suggest, in that context.
There's also language in the letter that clearly shows that he's a very controlling person. You're not seeing other people, right? That's because you're mine. You're not going to show up to testify, right? You're mine. That's the whole context.
Well, again, that's one way to interpret it.
Well, we have to interpret in the light most favorable of the Commonwealth, not your client.
Well, that statement is present, Your Honor. Again, the letter talks about many things, the relationship, money, things that might be expected the defendant would write about in the context.
Why the smiley face?
He says particularly there that he was talking about the financial issues. He was talking about the apartment. Financial issues were defining issue of the relationship, making ends meet. And there was something there about he was discussing the fact that, he hopes she can pay the bills and she wouldn't lose the apartment. And, he doesn't want anything to happen to her in a smiley face. So I think he was simply trying to communicate, as somebody would if in person, trying to communicate something, but trying to communicate the idea that I'm saying this to you in a way because I'm interested in your well-being. I mean, if you're talking face-to-face, you'd probably have a smile when you said something to somebody to communicate this. In a letter, you use a smiley face. So again, in terms of of how one might interpret the threat, we suggest it's much more similar to the Hamilton case, certainly than what Gardner relies on. In regards to ineffective assistance, we mentioned a couple cases. Day, in that case, the court allowed a photograph of the defendant indicating that he'd been held at Rutland Correctional Center. That was allowed into evidence. There's a comment in that decision that not only was trial counsel ineffective, but the judge and the prosecutor also faltered on allowing that to come in. Here, I would submit that the judge certainly thought that that letter should have been redacted. She asked defense counsel 3 times whether he would like to redact it. She asked 3 times. Defense counsel recognized there was a problem with the language. In fact, he had filed a motion to eliminate, to keep the letter out. But when that failed, he then chose not to redact the letter. There's another case, Reddy. There was some language that came in at that trial. There is a substantial likelihood of immediate danger of abuse. And again, there was a comment in that case that the evidence was not, of the underlying charge was not overwhelming, but the victim had also testified in that case, and we suggest that here, in Ostrander's case, the victim testified, but she mentioned at one point being fearful, but at the same time, you know, we'd suggest that the jury should consider it as a reasonable person. And within the context of the letter in its totality, we suggest is relatively innocuous.
Thank you, Mr. Conan. Thank you for your supplemental addendum. You're one of the few that actually complies with what we wrote in footnote 4 in Chase v. Curran, so we're grateful for that.
Thank
Mr.
you, Your Honor.
Greenbaum.
Good morning, Stephen Greenbaum for the Commonwealth. It sounds to me as if the court understands the Commonwealth's position. I would rest on my brief and attempt to answer questions if you have any.
No, seeing none, thank you. Is number 4 here? Do you want to do number 4? What's that?
Yeah.
All right,
If Ken, ask Ken.
we're going to do number 4. All right. The next case is 23P293, the Patriot Group versus Stephen FUSTOLO. Mr. Goldberg.
Hi, good morning, and may it please the court. My name is Lane Goldberg, and I represent Stephen FUSTOLO. The trial court's ruling here should be reversed, and the order should be set aside. Mr. FUSTOLO did not violate the 2012 injunction, and therefore, in modifying the injunction, the trial court abused its discretion. I'm going to first address—
Break it into 2 timeframes, though. Modification of the injunction prospectively and retroactively.
Yes.
I see a difference there. Do you?
I do. So the modification that the trial court entered as a part of this appeal, there's some impossible tasks of Mr. FUSTOLO to perform retroactively.
So are you challenging the judge's ability to modify the permanent injunction on a looking forward basis?
I'm not challenging the judge's ability to modify an injunction.
All right, so really what we're talking about is the retroactive application.
The retroactive application, but also the actual modifications that were made. So I am challenging the modifications that were made that made Mr. FUSTOLO perform tasks that are impossible of him. There's also punitive—
So says he, but I really want to parse this because I was confused by the brief on this point. The judge has the equitable authority to order from that day forward that the injunction be modified to include certain things. Let's put aside the other defendants for a moment. But as to your client, Mr. FUSTOLO, he can require him to do certain things going forward, right?
Yes.
Okay. So when we talk about impossibility and retroactivity, you're talking about, if I understand you correctly, you allege that your client's unable to recreate money in, money out, going back to 2012. Is that what you're saying?
Correct, yes.
Okay. So you framed it as an impossibility question. I guess my question is it a due process issue?
In terms of going back and recreating the record, I mean, it is a due process, it's a due process issue. The testimony before the trial court was that he had a bank account, the pool of money was in there, funds were coming in from different sources, they were commingled, is the word that was used.
Right, and nobody believed him, right? The bankruptcy judge didn't believe him, the trial judges here didn't believe him. Let's put that aside. What is impossible about saying to your client, you have to go back to 2012, Mr. Accountant, and recreate your accounting, your personal accounting? Why is that impossible? It might be a tremendous amount of work. It might take him days and days and weeks, but why is it impossible? He has control of the records of money in, money out.
Well, so what the order did, it said that he needs to go back 10 years, as you stated. He needs to identify the expenditures from all funds received in that account by Mr. Fustolo, his wife, anyone else acting in concert with him. And then it asks him to identify the specific source of funds for each expenditure. So the money that's coming in, it's all commingled into an account. There's a balance, let's say, of $10,000 of money that came in for that month. And then there's bills that are paid out of that. So how do you identify the source?
What year did the injunction enter?
2012.
And so he was on notice that as of 2012, the court was at least looking at money in, money out.
So you're correct, it entered in 2012 and then Patriot put him into bankruptcy. And that's one of the arguments in my brief, is that the bankruptcy stopped all of this.
Well, it stayed it,
Yes,
right? It didn't undo the orders, it just put a temporary pause.
well, it stayed the order for him to do this accounting.
So then what did he decide? Well, geez, there's a stay, let's just destroy all the records from that time frame because there's a bankruptcy stay?
No, but part of the injunction from 2012 requires, in paragraph 3, for instance, it requires him to make a payment to Patriot. So you can't parse out some of the requirements of the automatic stay to say, well, he can't make a payment to Patriot.
The whole thing was stayed. I'm with you for purposes of this question. Everything was on temporary hold because of the bankruptcy stay. Then the bankruptcy stay gets lifted, and I know it's then put in place a second time after the appeal, but why does that change his record keeping?
Well, it doesn't change.
He wasn't keeping records from the jump. That's his fault.
It changes his requirement to keep those records. If the injunction is stayed, then he's not required to keep those records for that time.
Like
So
a shell game with him, right?
Well, he's acting according to the 4 corners of the document, and then he's acting according to the law and the bankruptcy.
And the 4 corners say, you've got to account. A court comes in and says, I'm going to put that on hold. It doesn't say it's going away, you're relieved of your obligation. It's simply on hold.
Yes, it's on hold. So that's like saying a debtor in a bankruptcy, files a Chapter 7 bankruptcy, unfortunately doesn't get a discharge. For that year that he's in bankruptcy, fighting this bankruptcy, he has had to set aside those payments to his creditors. That's not how the automatic stay would work.
I don't understand why it sets aside his obligation to maintain his records. That was on hold. In the best case scenario, his obligation to maintain records was on hold.
Part of what the automatic stay does too, it stops, so under 362A6, it specifically states that any act to collect or assess is the key word there. So this injunction was, a major purpose of the injunction was an assessment. So it stops the assessment process.
Did it dissolve the injunction?
No, it did not.
Did it vacate the injunction?
It would have if the bankruptcy had.
Did it vacate the injunction?
No, it did not. The way that it played out, it did not, yes. But it would have. So in a situation where it would have, then he would not have had any of these. He wouldn't have had to go back and.
That didn't happen here.
No, it didn't happen. But that would say that any debtor that's in a bankruptcy would have to think ultimately this bankruptcy case will not succeed, so I need to do everything possible to make these payments, set these payments aside for creditors, do everything that creditors are asking with the assumption that the bankruptcy will not go through. That's not how the automatic stay would work. So he didn't look to, Patriot put him in the bankruptcy, so he was, under the automatic stay, and he stopped this, the injunction, the reporting on the injunction.
Why? I didn't hear your direct response to why it was impossible for him to comply.
So why is it impossible for him to go back?
Yeah. Tell me why. Not all the things that he would have to do. I want to know, why is it impossible for him to do those things?
He can't specifically trace where the language in there is, if you'll let me look at the language just one second, I apologize.
Sure, take your time.
That the specific impossible part here is that he has to identify the specific source of funds for each expenditure. So he has to match the funds that were commingled to the expenditure.
Has he tried to? Has he tried to do it? That calls for a yes or no.
That I don't know. It's not in the record.
Okay, so how can we say it's impossible?
Yeah, I mean, the other thing here is, for not doing that, there's these penalties that are in there. There's severe punitive penalties, which are not allowed.
They haven't been imposed yet, right?
They haven't been imposed, but they ultimately will be. So that's against what a contempt, what penalties under contempt can do.
He wasn't found in contempt, was he?
He wasn't found in contempt. So that's my whole argument here, is that he was found in violation, which is inherently, it's the trial court kind of, it was inconsistent with itself in finding him that he was in violation of something when that is inherently contempt.
So let's say you're right on that. The judge still has the equitable power to modify the injunction, at least going forward.
Yes.
Could the judge, rather than modifying the injunction going retroactive, could the judge have entered a new order requiring him to submit an accounting from 2012 to the present day?
I would still say that that's impossible based on the testimony that was before the trial court.
So to Judge Desmond's point, what year did it become impossible? So was it impossible to go back to, say, 2016, 2013, 2019? Like, when did it become impossible for him?
It would become impossible. So the bankruptcy, I believe, was filed in 2013. So the year reporting from 2013, from when the bankruptcy was filed and until he got out of the stay, and then there was a lift of the stay, and then it went back into the stay. So the time that it was in bankruptcy, he wasn't.
So once the bankruptcy action was finally completed, from that day forward, was it impossible?
From when it was filed, was it impossible? So that was sent to.
The case was concluded.
Yes.
Was it then impossible for your client to recreate money in, money out from the time the bankruptcy case was finally over until the time of the trial in the Superior Court?
So the reporting period from 2022, that was sent to Patriot for the year period before. So that wasn't, that was complied with, although Patriot does disagree with the, with how it was complied with, but that was sent after a motion to stay was denied in the trial court. But this also goes back to the fact that the trial court agreed that there wasn't a documentation requirement here. So I don't
know if they agreed to that or if they said that arguably it's ambiguous.
So, well, that's the standard for contempt. It has to be clear and unequivocal that somebody has to do something. So he didn't have to.
He wasn't found in contempt, right?
He wasn't found in contempt.
And Patriot didn't cross appeal. So really what we're talking about is the injunction. And so it's not lost on me that your client is a sophisticated accountant. And he says he can't recreate the money that came in and out to his family.
His testimony was that he doesn't use QuickBooks, he uses Excel, and that the pool of money was put into one account, whether it was his wife's income, whether it was residuals from different companies, everything was put into that account. So he can't trace, and I don't think if you even hired a person to do this, to trace the actual, what needs to happen by the trial court's order is that it needs to match dollar for dollar, dollar in, dollar out.
The expert that was hired to look at this, didn't that expert basically say that your guy has sort of created this, my word, scheme of how he's chosen to record his books and records?
So your word,
My word is
but
scheme.
yes. Well, the expert also stated that he used cash and cashier's checks. So how can cash and cashier's checks then?
I could buy that if he complied with it 80%. Here's the best I can do. I can't account for 20%, but I've accounted for 80% because I have deposits in and withdrawals out. I have checks in, I have wire transfers in, wire transfers out. He gave them nothing, zero, this sophisticated accountant.
Well, he did before the trial.
Well, the bankruptcy court and the Superior Court judge both found to be a fraud.
He did give them some documents stating that if, you know, the worst case of interpreting paragraph 4 of the injunction, he did hand over a spreadsheet of documents saying that this is in compliance with paragraph 4. If you're reading it the way that Patriot wants to read it, he did hand them those documents.
We're short on time. I want to ask you about adding, not the wife, but the other companies. Is it not res judicata based on the bankruptcy's findings about the nature of these two entities?
Well, so the nature of the entities, I don't think that you get specific jurisdiction from FUSTOLO CPE, which is a Delaware company. There's not enough there.
It does business in Massachusetts.
There's no business that's done in Massachusetts. This is a conference business. There's no conferences held in Massachusetts. There's no contracts here. The reservations for everything, it's held out of a company in
Do they have bank accounts
Florida.
Do they have bank
There's one
accounts?
bank account.
In
So
Massachusetts, right?
In Massachusetts, and the owner lives here. So those are the two kind of minimum contacts if you're going with that. But the Walden case is precedent here, saying that it's not enough. It's not enough to also hold these. So the trial court also added these other entities that were non-named, and there was no evidence from those entities. You know, the trial court didn't have any findings on those. I see I'm running out of time. I appreciate the questions. Do you have any other questions?
I could probably ask you questions for another hour, and I won't do that. I apologize to my panel members. I guess I don't understand, if I could, Mr. Panel Chief, I realize the red light is on. Can you explain to me in 30 seconds what the attorney's fee, have you actually been ordered to pay attorney's fees, or is that?
Yes, $15,000.
Okay.
Yes, so the awarding of attorney's fees, that's based on a successful contempt action, and here there was no successful contempt
I read the
action.
judge's findings on that, but I also read you to say, I'm sort of appealing, I'm not sure if it's ripe, I want to protect my rights. So do you think that the $15,000 order is ripe and before us?
I do, because it was ordered with the contingency of there could be more coming down the line.
That's all right. Thank you, Mr. Goldberg.
Thank you.
Mr. Siegel.
Jack Siegel, Your Honors, for the Patriot Group. Is there any particular thing that the court would like me to address? I didn't hear anything new from Mr. Fustolo's counsel that we haven't addressed in our papers. With respect to the entities, there's only one entity that's been added, and that's Fustolo CP LLC. The others, what's that? And the wife, yeah, the wife.
What's the jurisdiction over the wife?
She resides in the Commonwealth in Winchester.
Isn't she entitled to due process and notice? I mean, the company, I understand the argument. It's part and parcel of him, it's an extension. I'm struggling with the wife being added.
Well, if you read her testimony, that was included because we agreed not to have her come back and testify. So I think
Did you have to add her as a defendant?
we didn't add her as a defendant.
Don't you have to, is my point. How can a judge order somebody to do something that's not a party to the case?
Well, you can specify who, in the order under Rule 65, who the agents, partners, people acting in concert with, if there is a sufficient basis in the record to do so. And I
Give me
think
a case that says that.
I'd be happy to submit one, Your Honor.
One in your brief?
I don't know if I addressed that particular issue to that particular degree in my brief. Because what you have is you have a 2018 trial transcript where she testifies that she became aware of the injunction because there was, before the bankruptcy happened, there was post-judgment discovery, and she was deposed. She became aware at that time. She was responsible, and Mr. Fustolo testified, I believe it was on the second day of the trial, that his wife and he continue to write checks for the expenses. She was involved with that. She paid what her husband told her to pay and did what her husband told her to do. She lent her credit cards to his companies because they themselves couldn't get. So I think if you drill down to whether or not...
Cite a case. You cited the Bird case, and I'll take a look at that. Do you think that the issue of CPE LLC is res judicata based on the bankruptcy court findings?
I think it's res judicata. I think there's jurisdiction based on the fact that there had been two bank accounts. One may be operative. I think there's $33,000 that's been reached and applied to one of the accounts in a parallel action. They appeared in a parallel action and filed an answer and generally appeared. Ms. Fustolo had a contract with Fustolo CPE to provide services. She resides in the Commonwealth. Mr. Fustolo resides in the Commonwealth. He apparently has loans, and there's payments, monetary payments for his services that have been going on since 2014.
After time, I want to switch gears for a minute.
Sure.
How does the judge find him not guilty of civil contempt, but find that he violated the injunction?
Easily, because civil contempt requires a level of intent, and a level of willfulness, and requires clear and convincing evidence.
Right, Burchell set the standard high. Where do you find that there's some lower standard? You're not in contempt, but you violated the order.
I find
What is
it.
that?
I find it all the time when I go into courts and people say so-and-so violated my order, and they're not found in contempt. For example, in a discovery motion or something along those lines.
It's a temporary order. This is judgment, right?
It's a permanent injunction, yes. So what I think the court certainly can do is can say, regardless of what your intent was, and say, like, I'm not going to go so far as to say that there was enough specificity in this letter, but we all know exactly, like, his interpretation of the letter of the permanent injunction was there was no spending limitations, there was no documentation requirement, that he was completely left on his own to decide whether or not he ever did anything.
There's still an internal inconsistency in Judge Wilkins' rationale and decision. Right, there's still an internal inconsistency, but you didn't appeal the not guilty finding. So I want to move forward to what I asked counsel to really separate out the prospective modification to the injunction versus the retroactive. Can you address why this is not impossible?
It's impossible because there's been no demonstration of impossibility, and an impossibility is a defense that Judge Wilkins specifically reserved for them to raise to the extent that we move for contempt for his failure to comply.
Mr. Goldberg says some documentation was provided to Patriot. I'm going to have to look for it in the record. Did you receive any form of an accounting?
I received accounting from, well, first of all, he introduced at trial an exhibit that you will find where he purports to do what he says he cannot do.
Right.
Okay? So that's one thing. The next is, after the trial was over, and in the interim period, he filed two motions to stay. I think he filed one in the Superior Court, he filed one in this court. Both were denied. When the one for a stay was denied in this court, I received some paperwork that's not in the record. And the paperwork itself is very thin, very incomplete, and purports to exclude the company that Mr. Fustolo was ordered to include.
Do you have the appendix easily at hand?
It's back at my bench.
All right, let me get it.
Yeah.
Okay.
But in fact, before the contempt action, he submitted a statement purporting to show expenditures going back to 2012 from each of the reach and apply dependents, and then he did the exact same thing at trial with even more specificity, claiming, look, I could do this. In fact, I've complied with this injunction. I don't know what you're talking about, even though it didn't require me to do anything.
I know this is somewhere in the record, but of the $42 million judgment, how much have you been paid?
Zero. We won an award of attorney's fees as a sanction in the bankruptcy case, and he was required to pay us $30-something thousand. He's going to claim that that's an offset of some kind, I'm sure, but we've received nothing. Yeah, not one dime. I mean, I have nothing more to add other than what's in my papers. If Your Honor wants a supplement on the case for the due process issue, all right, thank you, Your Honors.
Thank you.
Rest of my papers, thank you.
Thank you both. We're going to take a short recess.
Court is now in session. Please be seated.
Our next case is 23P207, Chad CROWTHER versus Joel Asadoorian. I said that right? Maybe. Mr. LaFortune.
Thank you, Your Honor. Good morning. It's Attorney Steve LaFortune. I represent the plaintiff appellant, Chad CROWTHER. I don't have too much to add. It's not in my brief. I set out numerous arguments whereas Mill City and Mr. Asadoorian can be held liable. Mr. Asadoorian's own negligence and successor liability for both Mr. Asadoorian and Mill City, and the failure to preserve business records, which prejudiced my client. Set forth a number of cases, set forth the management agreement, I set forth the bill of sale. It wasn't an asset purchase. The bill of sale sets clearly that the asset purchase was $90,000 something, where the purchase price was $178,000. He also, Mr. Asadoorian and Mill City also purchased the goodwill of the business.
The agreement also says that Mill City didn't acquire any of Hayhurst's liabilities.
I think there was an indemnification agreement. I didn't see any part, I don't recall that being in there. I recall there was an indemnification agreement between Mr. Hayhurst and Mill City that Mr. Hayhurst would indemnify Mill City.
At the time of the sale, had this lawsuit been filed?
No. But there was actual knowledge, as I put, Mill City and Mr. Asadoorian had actual knowledge through the manager. The manager for Finn's Pub and Mill City were one and the same. Everything continued with the sale except the name of the pub. So all the employees and the manager of Finn's Pub went over to Mill City.
For like 3 months, is that right? Or for continuous?
Continuous. Mr. Papoulis, and I put his deposition testimony, was the manager of Finn's Pub. He allegedly was the one who engaged in the assault of Mr. CROWTHER. And then when the pub was sold in September of 2015, everything continued over. He was the manager of the Mill City Pub also at the same location and the same employees. The only thing, based on the record, the only thing that changed was the name of the pub.
And didn't they renovate it?
I'm sorry?
Didn't they renovate it? I thought they did some construction and closed it for a while and...
No, Finn's Pub was closed by order of the city for a while. Their hours were reduced, and they went out of business. And they may have done some minor renovations, but the pub was essentially the same employees.
Different name, different ownership.
We don't know if it's different ownership. The only thing we have is one corporate records. We don't have the business records. Neither Finn's Pub or Mill City preserved any of the records.
We know that how do you pronounce his name? Asadoorian wasn't involved in it, right? Prior to September 2015.
Yes, he was. He was the, prior to the assault, a week prior to the assault, he was president and manager of the pub.
Of Finn's?
Of Finn's Pub and Mill City. Mill City was going to buy Finn's Pub. They had a management agreement. That was just prior to the assault. And as part of that management agreement, Mr. Asadoorian became president and manager of Finn's Pub. And with the contemplation that he would then purchase the pub at some later time. So, and he testified that he knew the security was inadequate just prior to the assault and did nothing. So he had the authority and control to at least hire employees. He had the authority and ability personally to inform Finn's Pub ownership that the security was inadequate, and that's all on the record.
Did you, correct me if I misheard you, but you said that it was really the same company from before and after the incident.
I said it was the same business. All the employees went over to Mill City. The ownership records, the only thing we have is the corporate records filed at the Secretary of State. All the business records were destroyed for both Finn's Pub, destroyed or not retained. And in this instance, it has to be looked at Mr. CROWTHER's favor. of Finn's Pub in Mill City. They didn't retain any of the records.
What records would you need?
Well, I would need who was paid, I need the shareholder agreement, to determine ownership, I would need all those records. And these guys weren't, if you look at the record, these guys weren't the most character-strong people. I mean, and they initially tried to deny the assault even occurred. And they were, Mr. Papadopoulou was prosecuted criminally, and the city had enough and limited Finn's Pub's hours because of the assault, the ongoing character of this business, and because they had misrepresented the factual history to the pub. And with the hours limited, Finn's Pub then went out of business and sold its entire business to Mill City and Mr. Asadoorian. So I'm arguing that that's one theory of liability, successor theory of liability.
So the judge rejected that argument, right, with respect to the business records?
Yeah, didn't hold a hearing or anything. It was a summary judgment argument, and
I'm just saying he rejected it. He said that you weren't able to show that the records would have helped you one way or the other.
Well, he made a conclusion as if he was a factual conclusion. That's his determination. This is a de novo hearing and a summary judgment hearing. The records plainly could have helped minimally with the case against Finn's Pub, because what I had to do was go on witnesses. I didn't even know all the employees' names. It plainly could have helped with the security camera that was there. Mr. Papadopoulos was the manager, again, of both Finn's Pub and Mill City. After the purchase, he testified there was a security camera of the event that night. Never went into evidence because they never produced it, never preserved it. So a number of issues that I put in my brief where the evidence could have been helpful to business records, and it certainly could have been helpful in showing the ownership status.
The judge found nothing nefarious about that, right? The judge said he had no reason to really hang on to the camera.
Well, and that's his conclusion. I mean, I argued in the brief, and that's a summary judgment conclusion. Your honors would have to make that determination on your own de novo. But I would argue, and I could reasonably argue before a jury, that immediately after the assault, the police were investigating. The security camera wasn't disclosed. The City Alcoholic Commission was investigating. The security camera wasn't disclosed. And based on a reasonable inference, if that security camera had exonerated Mr. Papadopoulos and Finn's Pub, it would have been produced.
Can I ask you about Mr. Asadoorian? The defense say that he's wasn't an employee at the time or otherwise, not responsible for the operation of the pub, and he played no role in the assault and wasn't present at the time of the assault. So where does his duty of care arise from?
Well, he was shortly before the assault, he was the president and manager of the pub. So he may not have been, I don't know if he was physically present, that's what he testified. But he was president and manager of the pub shortly before the assault, and he testified that he knew the security measures were inadequate, and he had the ability to hire security and retain additional employees, and he didn't do so, right in the management agreement, a week before the assault. So he has personal liability, and I cited those cases.
So he was president, he was at the time of the assault, or you said shortly before?
Just shortly before the assault, Your Honor.
But not at the time of the assault?
Well, according to them, he wasn't. But I'm arguing that, also argued that on the successor liability, that partnership joint venture doesn't end under Massachusetts law until the purchase was consummated, which was in September. So he may or may not have been physically present that night, but I'm arguing that as a matter of law, he had a joint venture partnership obligation with Finn's Pub before the assault and all the way through during the assault until September when they purchased the
But did you put something in the summary judgment record that supports your legal theory?
Yes. I mean, put in the management agreement, and I put in the bill and sale. And so in all the testimony from Mr. Hayworth, that essentially was a sale of the business. So under dissolution of partnership or joint venture law in Massachusetts, and I cite those cases in that law, that joint venture or partnership with Mill City and Mr. Asadoorian commenced in December of 2014. The assault occurred in March 2015, and that joint venture partnership didn't end until September of 2015 when the purchase was consummated. And that's one of my theories of arguments that I'm making. I have numerous theories to hold Mr. Asadoorian and Mill City liable.
So the judge said, with respect to the bill of sale, that it included no provision in which Mill City assumed expressly or impliedly the liabilities of Ahurst. So what do you say in response to that?
Well, I respectfully disagree. I think it was incumbent upon Mill City as the drafter to say that they were not taking the liabilities. And in that agreement, it says they're purchasing the goodwill of the company. Goodwill, by definition, you take the assets and liabilities of the company, and the goodwill is the intangible value afterwards. If you look at that, Mill City's contending it's an asset purchase agreement. If you look at that agreement, it's $98,000 for the assets, and then there's additional monies for the goodwill. And I'm arguing that the purchase of the goodwill, essentially the entire business, it's not an asset purchase agreement. You're purchasing the whole kit and caboodle.
But at the time of the sale, this case hadn't been filed yet, right?
No, but it doesn't, you don't have to have an explicit, that the event had already occurred, the liability had already occurred, the assault had already occurred, the negligence had already occurred. So when you purchase a business, as a matter of due diligence, you either do it one of two ways. You have just merely an asset purchase agreement where you just purchase the assets, you don't purchase the business. That's one safeguard to do it. Unfortunately, it doesn't appear any of these parties had attorney at the purchase, at the time of the purchase. So either you do an asset purchase or you do your due diligence and interview people and have representations that there's no liability and have an indemnification agreement. The problem with the indemnification agreement is it's only as good as Finn's Pub.
If he had done his due diligence, he would have learned that there was no lawsuit filed.
No, but everybody knows that a lawsuit can come within 3 years untoward if you talk to any attorney. And another point was Mill City and Asadoorian, before the assault, procured insurance for the pub, insuring themselves. So they knew there was a potential for liability, and they knew that they
Was the insurance for that part of the pub, or was it for a different part of the building?
No, my understanding is, and I don't think they dispute this, is that the insurance was for Mr. Asadoorian and Mill City's actions regarding Finn's Pub, because he was the manager and president, he was going to purchase it.
I'm not sure that's undisputed.
Well, there was insurance for the pub, and if there is a dispute, then that's to be resolved at trial. So I don't know if you want me to repeat all the theories of liability, but...
No, that's okay. Did you have anything else you wanted to tell us?
Just the final point about the business records, even if they didn't know about the lawsuit, they had a requirement to keep those business records, and they didn't, including the security camera. Thank you.
Thank you. Mr. Byrne.
Thank you, Your Honors. Michael Byrne for the defendants, appellees, Joel Asadoorian and Mill City Suds Incorporated. This is, I think, a pretty simple, straightforward case in that it's an assault that happened in a bar and a patron was injured. The only wrinkle here is that the plaintiff has gone to great lengths to try to argue that my clients are somehow held responsible for that, even though neither one of them had anything to do with the operation of the bar on the evening in question. Mill City Suds purchased the assets 6 months later. Mr. Asadoorian had temporarily served as manager of the pub for a period of 3 months as a sort of prelude to purchasing the bar. As it turned out, That didn't happen. He didn't get along very well with Mr. Hayhurst, the current owner of the bar. There were some conflicts over what money was being spent on, management issues, and they agreed to part ways. They terminated their agreement. That happened 10 days before this accident happened. So what we now have is a situation where neither one of these entities can be held directly liable for anything that happened on the night of March 17th, March 18th, 2015, and what the plaintiff has attempted to do is either reach forward from the management agreement by recasting that as some sort of partnership or joint venture that couldn't be undone, and therefore that Mr. Asadoorian and somehow Mill City, which wasn't a party to that agreement, now become liable for anything that happens after their involvement under the management agreement.
What if instead of an assault, what if it was, a slip and fall? So, is your argument the same? Does the fact that this was an assault does it change the dynamic at all?
I don't believe it does, no. I think if it were a slip and fall, it would still be an issue of control, and there's no right of control here because neither one of these entities has any interest in the property, or neither Mr. Asadoorian nor Mill City Suds has any interest in the property or any responsibility for the operation at the time of the incident.
What if it was like a non-payment of wages claim? A waitress wanted to bring a claim for non-payment of wages. Would your clients have any liability under the same timeline set out in this case?
No,
I'm trying to figure out what goes with your client, if anything, in terms of liability when if the sale happens.
I'm not sure I understand. Are you asking that as a result of the sale in September,
Yes.
do they have any responsibility for anything that's left over?
Right.
I believe under the corporate successor liability theories, there are very limited exceptions. One is where the parties have expressly agreed to transfer some of the liabilities over to the successor corporation. That's not the case here. There's nothing in the agreement that contemplates that. To the contrary, there is an indemnity provision which makes it pretty clear, I think, that there was no intention that the risk was going to be shifted onto the shoulders of the purchaser. The argument that somehow because goodwill is included, that must mean something. It makes very little sense to me to suggest that someone would pay more for a business in order to obtain their liabilities than they were willing to pay strictly for the assets of the business. I think that's counterfactual and counterintuitive. I don't believe that there was any intention, express or implied, and the judge found this, to take on any of the liabilities of the predecessor corporation of the Hayhurst Group. And so then we end up with, then we're looking at the other possibilities here, one being a de facto merger or mere continuation, which are kind of used interchangeably, although they're not quite the same thing. De facto merger, you have two companies that are coming together, and they are continuing the business that one of the companies had previously been operating, but now they're jointly combining forces to continue operating. And then mere continuation is sort of where the owner of the business creates a new corporate entity, transfers the assets over to the new corporate entity, puts on a new hat, and then continues on its merry way, continuing to operate the same business. In both of those cases, there are a number of criteria, but I think the most significant ones are, is there some continuity of ownership and management and control from before until after the transfer takes place? And here there isn't. Mr. Asadoorian played no role in the ownership or management of Hayhurst Group, which owned the property or owned the assets up until September. And conversely, Mr. Hayhurst owned no portion of the ownership, no shares, no officer position, no control over Mill City Suds, which ran the business after September of 2015. There is no overlap here. These are two different companies. They came together, they sold the assets from one to the other. Happens all the time. The other theory here And also, just on that issue, just as an aside, there's an allegation here that essentially it was the same business, the same people, nothing changed, they just put another sign on the door. That's not the evidence in the case. The evidence in the case is there were, I think, 2 employees that did carry over. Some of the bartenders may have left and come back subsequently while it was under Mill Cities. There's, and there's wait staff there. People come and go. So there may have been others, but this is not, there was certainly no continuity of management, other than Mr. Asadoorian, who had previously served in the management role in a limited capacity for 3 months, which had terminated a week or 10 days prior to this incident. Setting aside then the de facto merger mere continuation, then we're left with fraud. There's no allegation here. There's no evidence here to suggest that somehow Mill City Suds or Mr. Asadoorian was participating in any fraud or would have any incentive to do so. If Hayer's group were liable to Mr. Crowther for the fight that had occurred in March, there's nothing for Asadoorian and Mill City to gain by assisting Hayhurst in trying to escape liability for that, or trying to cover that up, or trying to get rid of records. This spoliation argument that cropped up in the case.
Hayhurst settled?
Hayhurst settled. I don't know what the terms of the settlement were. It was after the summary judgment was entered in favor of my clients, and frankly, I personally was not involved in the case at that point, but I don't believe we know the terms of the settlement. But yes, after the summary judgment was entered for Mill City and Mr. Asadoorian, Mr. Hayhurst Group, and Mr. Finn settled the case as it was approaching trial, and then the only claim left standing at that point was the one that had already had the summary judgment entered on it, and that's how the case came up on appeal. As for the spoliation argument, just briefly, what happened here is that all of the business records of Finn's Pub were kept on, at least the testimony is all of the records were kept on a sort of point of sale system on the computer. It was in the office. The computer was one of the assets that was transferred from Hayhurst Group to Mill City Suds, so they got it. Then they kept their own records on there. Then after 10 months, realizing the business isn't profitable, things are not going well, Mr. Asadoorian and Mill City elect to sell the assets to LD Holdings and Lauren DeSalvo, who were the other defendants in the case that were previously dismissed. Everything goes with, as it did when Mill City took over, everything goes with the building or with the bar. And then when Mr. Asadoorian goes back afterward, not realizing they're going to change the locks on him and not let him back in to get his stuff after the sale closed, he goes back, he tries to get the records and is told no. So there is no sort of deliberate destroying of records here. And at the time all of this happened, he had no idea that there was a suit in the offing, or that there conceivably could have been, and certainly not a suit against him or against Mill City, because that happened prior to, not on his watch. And so there is no valid basis for a finding of spoliation of evidence here, and certainly not sanctionable spoliation of evidence. That's not a de novo standard, as my brother had indicated. That's the summary judgment ruling is certainly a subject to de novo review, but the judge's ruling on the appropriateness of a spoliation sanction in the case is a matter of discretion on the part of the trial judge. He has broad discretion in that area, and we would submit that he absolutely did not abuse that discretion under these circumstances. Finally, there's been mention of the destruction of a video. Mr. Papoulias testified that while the pub was being operated by Hayhurst Group, there was a camera and there was a video feed that was visible in the office. He did not have access to it, but he knew that it was there. So we don't know if it was turned on. We don't know if it recorded this incident. We don't know what happened to the recording, if there was a recording. We don't know what happened to the camera, because it's not listed among the assets that get transferred to Mill City 10 months or 6 months later. And Mr. Papulias testified that when Mill City was operating the bar, the camera wasn't there anymore. So there's no evidence that Mill City or Mr. Asadoorian ever had the camera or the video, if there was a video. And so there's no evidence that Mr. Asadoorian or Mill City could be held responsible for spoliating that hypothetical evidence, which nobody can say whether it exists or not, or ever existed, and certainly can't say that it was ever in the possession of Mr. Asadoorian or Mill City. And so we would argue that the court absolutely did not abuse its discretion in denying the motion for a default on the basis of spoliation, and that the plaintiff failed to present any viable argument to establish that either Mr. Asadoorian or Mill City could be held liable derivatively for the negligence of Hayhurst Group or Mr. Hayhurst on the night of the incident, nor was there any evidence to hold either Mr. Asadoorian individually liable for negligence on that night or to hold Mill City responsible for the operation of the pub, which they didn't buy until 6 months later. Unless Your Honors have any other questions, I'll rest on the brief.
Seeing none, thank you. Thank you both.
Thank you.
Our last case is 22P880, DICIENZO versus Angela PIZZIFERRI. So before we start, I think you've been here through a couple of cases and you can see how things work. You're going to get 15 minutes to tell us what you'd like. You'll probably get some questions. Mr. Salmon will not interrupt you, and you're not permitted to interrupt him when it's his turn as well. There's no rebuttal, so you have to tell us everything in your 15 minutes. You needn't use all of your time, and we have read everything.
Can I read now?
I'm sorry?
Can I read something?
Oh, yes, as long as it's brief.
May it please the court, my name is Angela PIZZIFERRI, and I'm the defendant applicant in this matter. I'm not an attorney, and I'm very nervous because I usually do not speak in public, so please excuse any lack of knowledge with this process. I'm resting on the brief and the arguments that I have made. My position is that the lower court judge erred when he concluded that because of the provisions on the Massachusetts Uniform Trust Code, I had no basis to proceed to defend this case. I respectfully maintain that the lower court decision is flawed because the section of the MUTE that the lower court judge relied upon, section 704A6, does not have a mechanism that addresses the procedure that should be followed when a ward regains testamentary capacity, even for a brief period of time.
Well, the capacity doesn't come into play if once she's appointed a guardian, which you and Ms. Lara had yourselves appointed guardians, and under that section 704A, it says once that occurs, she can no longer serve as a trustee, and since she's not a trustee, she can't deed the property to anyone.
Well, but she never had, like, what is it called? The probate court never had an independent request for my aunt's competency, and she was also appointed a conservator at the time.
But he decided that, I think it was a he, that he didn't need to reach that issue because as a matter of law, she couldn't transfer the deed because you convinced the probate court that she couldn't handle her own affairs, and I think there's medical evidence that supports that.
Well, she was also appointed temporary conservator for her assets, and he did that from 2013 to 2016, and when he resigned, he notified both plaintiffs, so they had plenty of time to come forward as successor trustees.
But you didn't, the plaintiffs had no, as my understanding, and correct me if I have it wrong, the plaintiffs had no understanding or knowledge that is it Antoinetta had transferred the property to you.
Well, that's false, because the reason why we became the guardian is because Nicola abused her. Quincy police had called my sister, and she was found with a broken hip because once he found out he could no longer rob from her, he beat her up and left her on the side of the road.
Why didn't you then record the deed as soon as Antoinette signed it? Instead, you waited till she died.
I didn't feel I had a need to.
Was there any criminal proceeding that went along with that assault and battery that you're talking about?
No, unfortunately, there was no evidence. So Elderly Services recommended we became guardian because they feared when she was in rehab that Nicola would go in there and discharge her, and who knows what he would have done to her. So the reason why we became guardian is because we were afraid of what Nicola would do to her. He already broke her hip, he robbed her.
She suffered from Alzheimer's?
Yes.
And at the time of the transfer to you, how long had she had Alzheimer's?
I'm not sure of that.
How long are you sure that she had Alzheimer's?
Well, I believe in 2013, at the time of the incident, Dr. Maggio, the doctor, said she had dementia.
And that was reflected, you witnessed that, right?
Witness what?
That she suffered from dementia.
Not really. I think she was very...
Didn't you sign something that said she was unable to take care of her own personal affairs? Didn't you sign that?
I did.
Okay, why'd you sign that?
I don't know, Elderly Service, we did exactly what Elderly Service told us to do. And there was only one medical certificate, which was in 2013. And after that, there was nothing. They mailed it to us and we mailed it back.
So even though we're supposed to ask you questions, I just want to clarify that for you because I understand that you're self-represented, but a medical certificate is only required when someone seeks to be appointed a guardian or seeks to resign. Every year, the guardian, like you and your sister, are required to file a guardian care plan report to make sure that the person is still involved with the incapacitated person. So it isn't a problem legally that there wasn't a medical certificate because it was filed when it was supposed to be. The only thing that's supposed to be filed every year is what you filed, and you did that correctly. So I just wanted to clarify that for you because I think you confused the two reports. At any time, did you ask Mr. Parker, the conservator, about transferring the deed to you?
No.
And you understood as guardian that you were responsible for her day-to-day, assisting with her activities of daily living and things like that, not her money or her assets, right?
We were never responsible for her money and assets. David Parker was.
Right, that, and
Up
you
until
understood
2006, yes.
Okay. And you were appointed in 2013, and the deed was signed in 2016?
Yes.
And there had been no court order that said she no longer required a guardian at that point, right?
It was conservator. There is an order that she...
I asked you about guardian.
Oh, no.
Who is David Parker?
He was the attorney that conserved the assets up until 2016.
He was a professional consul.
Yeah, he was appointed by probate court in 2016.
Did you have
2013. In 2013, he resigned because he didn't feel that she no longer needed conservatorship.
Is there anything else you'd like to tell us?
I just feel like that I didn't have the, this was on summary judgment, so I feel like I didn't have like a hearing or a trial to at least present everything, because there's a backstory for why she was the guardianship, and the children claim they had no knowledge or anything, but they were notified several times of what was going on, and they never stepped up. And there's also in the trust implicates that they're supposed to step up, which they didn't.
Do you live in the property?
No.
When you had it transferred over to you for the $1, you didn't take any action immediately after that?
I'm not the one that transferred, she did.
No, once it was transferred to you?
Yes.
Right. And once you received it, you didn't take any action until 9 days after Antoinetta passed away, is that right?
Yes.
Why?
I didn't feel the need I had to, so I didn't. It was Joe DiCienzo. He gave me a call after she passed away, which was her brother-in-law, because he also was, at the time, before Nicola beat her up and threw on the side of the road and we became her guardians, the brother-in-law, Joe DiCienzo, was taking care of her assets. he went into the office and threatened him, so he resigned, Joe DiCienzo. So that's when Nicola went in and said, are you taking my aunt to the bank, withdrawing large sums of money? And the bank teller called my sister and said that I don't feel like this is, right. She's withdrawing large sums of money. So we called the Quincy police, and that's when everything came into play. There's like a backstory to why she became guardian. It was not because she was incompetent or anything like that. They feel she did have dementia, but I believe she knew exactly what was going on.
Who drafted the deed transferring the property?
I'm not sure. I believe Joe DiCienzo, her brother-in-law.
Do you know who Tony Romero is?
Yes, he was the notary public.
Did you know him personally?
No. I just feel like I deserve some type of trial or something to just bring everything together. The children were a no-show for 10 years. And then as soon as she passed away, they knew exactly what was going on. They waited till after she passed to come forward. They could have came forward at any time. They knew exactly what was going on. They were the beneficiary of the trust. They signed it. They knew that my aunt was living with her sister and stuff. They never questioned anything. Why did they wait till after her death to come forward? It was not my action, it was their actions. They neglected their mother. They didn't follow the rules of the trust either. They neglected the property and everything. So in 2013, if they knew I was her guardian, why didn't they step up?
Okay, thank you.
I appreciate it.
Mr. Stammen.
Good morning. The lower court's decision is based on the application of 203E, Section 704A, under which it's clear that following the appointment of Ms. PIZZIFERRI as Antoinetta's guardian, she no longer could serve as trustee. Therefore, the deed is void. If the court were to consider de novo the issue of Antoinetta's capacity, Ms. PIZZIFERRI cannot take the opposite position in this case that she did in the probate court, which is that now, when it's convenient for her, Antoinetta had mental capacity to contract. Ms. PIZZIFERRI signed annual reports under the pains and penalties of perjury that Antoinetta lacked capacity. The court found that Antoinetta lacked capacity, and as a matter of collateral estoppel and judicial estoppel, Ms. PIZZIFERRI can't raise the opposite position in this case.
Ms. PIZZIFERRI does say that the land court did not have jurisdiction.
The land court had jurisdiction over the equitable claim to title to land under the provisions of 185, Section 1K, and under 231A, Section 1, they have the right to issue declaratory judgments in areas that it has jurisdiction. They clearly did have jurisdiction. Furthermore, in the land court case, Ms. PIZZIFERRI was served with discovery in which she was given an opportunity to provide any evidence that she had, and also at the summary judgment stage that rebutted the fact that that Antoinetta lacked capacity, and she failed to produce anything in that regard. The land court's decision was proper, and it should stand.
She was represented below, right?
At times.
Anything else? Thank you. Thank you both.
Thank you.
We'll take this under advisement, and then we'll issue a decision in writing.
Thank you.
That'll conclude our session today. With that, I'd like to thank my panelists, the court officers, the clerk's office, our excellent timekeeper, and of course, our litigants. With that, we'll stand in recess.
All right.